I'm Vinny Politan. Thank you so much for joining us here on Closing Arguments. The trial that we are covering down in Bartow, Florida, is all about the final moments of a young father's life. Adam Hilaire was his name. He was a young dad just living his life, had a young daughter. And for whatever reason, this group of criminals got together with this scheme to somehow lure him through this dating app and then scout out his apartment and figure out a way to rob this guy through a home invasion. I don't understand the whole plan. I don't understand. It's about nothing. What is it about? A video game, a TV? It's ridiculous. Absolutely ridiculous. But this trial isn't about all that. This trial is about the last moments of his life. This is a man who had one thought on his mind. One thought, as that gun was held to the back of his head. And that thought was about his daughter and what her life would be like without him. And he begged the man holding the gun to spare him so he could be there for her. Adam Hilaire is a hero because his true character came out in the final moments of his life. It wasn't about him. It's about his daughter. But it wasn't enough to save his life. It wasn't able to convince the man with the gun to not take his life. That man was convicted. His name is Andre Warner. He was convicted by one jury, and now another jury is deciding whether or not he gets the ultimate punishment for the ultimate crime. And today, prosecutors delivered their closing argument in the penalty phase of this case, trying to convince this jury that Andre Warner should go to death row.
Clearly, the circumstances surrounding Adam's murder show that it was heinous, atrocious, and cruel. The pure evil that exists in this defendant is demonstrated by his lack of pitilessness, consciencelessness, as Adam begged for his life for his 5-year-old daughter. Let's put this in perspective. This is what Adam's life was worth to the defendant. All fits in this cart. But after the defendant chose to take Adam's things, instead of making the choice to leave Adam there so he could raise his 5-year-old daughter, he made the choice to go back into Adam's apartment and execute him. He made the choice to stand behind him, to hold that firearm to the back of his head, and to pull that trigger. He made that choice. Not Adam, the defendant. Not Gary Gray, not Haley Bustos, not Josh Ellington. Andre Warner made that choice.
Powerful closing argument from the prosecutor. Let's bring in Court TV crime and justice reporter Joy Lamb-Nakrin, who's joining us tonight from Bartow, Florida. Joy, I want to start here. Is it true that this defendant did not even have the guts to be in the courtroom during these closing arguments today? That he chose to not be in the courtroom and listen to the prosecutor talk about what he did to Adam Hilaire?
Yeah, he waived his right to appear during closing arguments. It's really not clear why. Perhaps it is because he didn't want the jury to see his reaction or read his body language. But yes, he did, in fact, waive his right to appear during closing.
Okay, tell me about the moment, because I thought the prosecutor did a really great job. You know, prosecutors all deal with the penalty phase a little bit differently. This one, though, I mean, she really laid things out. How was it received by the jury? It was a long day.
It was a long day, and both sides took a lot of time for their closing arguments. That particular moment that you just played, very dramatic moment for the state, but there were times when the state got into a lot of nitty-gritty detail, and of course getting into the law and the elements of proving aggravating factors, and then trying to rebut some of the evidence that the defense had laid out, really getting into some of the nitty-gritty regarding the testimony about Andre's childhood, what his mom said versus what his aunt said, stuff that didn't quite add up, such as, him wearing a helmet for, X amount of time. And there were points when it seemed like the jurors were actually losing focus. We even caught one juror nodding off during the state's closing arguments. So, it remains to be seen whether that will overshadow those more impactful moments like what you just played.
Yeah, absolutely, because I think that's what this case is really all about, and this penalty phase is all about. Let's introduce tonight's think tank. Joining us, folks, tonight in Atlanta, Georgia, the attorney for several of R. Kelly's accusers, Gerald Griggs, is with us. In Houston, Texas, criminal defense attorney Carmen Rowe, and also in Houston, Texas, criminal defense attorney Brian Weiss. Great to see everyone. I want to start here with the fact, Gerald, that he's not even in the courtroom for the closing arguments. His life is on the line, and this guy is that much of a coward. I mean, is there any other reason to not be in the courtroom during the penalty phase and the closing arguments of the case?
I think it's important for the defendant to be there so the jury can judge his mannerisms, watch his body language. So I think it was a tactical mistake. It was probably the choice of the defendant against advice of counsel. But I think they always need to be there, especially during the closing arguments, so that jurors can sense everything that's going on with them and judge them from that point.
Carmen, I don't understand this. I don't know if I've ever seen this before. He's there for the whole trial. I mean, he testified, all of that. All of a sudden, now he's making a quick exit?
It's interesting because I actually saw it as a sympathy ploy throughout this entire sentencing hearing. He's been putting his head down. He's trying to evoke this notion that he's sympathetic, that he's sorry about what happened. And maybe this was just so overwhelming, he couldn't be there to listen to it today. So that was kind of my sense. I don't know if that's how the jury will see it.
Brian, I know you're the king of the appeal. Is this some sort of backwards appellate setup? Trap or something that they're setting up here, the defense, in case this jury does in fact send him to death row?
Absolutely not, Vinny. I think there's nothing at all about this defendant's decision to waive his presence during literally the most important part of this trial in any appellate issue. I agree with Gerald. This was a huge tactical error, but then again, this is a man whose life doesn't seem to be animated by making any decision of any substance, anything that comes with, again, within an area code of making sense. And I think what's clear is that juries want to be able to look someone in the eye when they make any decisions to sentencing, but particularly life and death. And that decision is always going to be easier to sentence somebody to the ultimate punishment if they're not in the courtroom and they're not even human in the eyes of this jury, man.
Yeah, I agree with you. I think he should be there, but, they dotted the I's, crossed the T's. He waived his right to be there. I want to take a listen to part of the defense closing argument. And again, both sides very passionate inside the courtroom, doing the job that we want them to do. Let's take a listen.
In terms of reconstructing the shooting, we are here in a death penalty case. And I'm going to say this a lot. Are you kidding me? Are you kidding me that the Delaware Valley, the crime scene tech, comes in and says, well, he could have been on his knees. And yeah, there's some blood spatter without any analysis. And somehow that's proof beyond a reasonable doubt. Could have. That's not proof beyond a reasonable doubt. The idea that the state relies on a property crime detective to reconstruct a crime scene? Are you kidding me? The guy worked in patrol. He spent 2 years as a property crime detective who went to some crime scenes and then is back in patrol. And that is who they use to reconstruct the crime scene. I'm sorry if it costs the taxpayers money for us to bring in a crime scene expert But they are trying to kill our client. Are you kidding me?
Defense attorneys, I appreciate all the passion, but I just don't buy they're trying to kill my client argument. It's the law. Down in Florida, there's the death penalty. It's been passed by the legislature. It is the law. And if a prosecutor ethically believes that this guy is the worst of the worst, the aggravating factors apply, they seek the death penalty. That's the way it works. It's the law. It's not like we're trying to kill somebody, trying to execute someone based upon what the law is. Let's bring back in Joy Lim Nakrin, Court TV Crime and Justice reporter. Let me ask you about this issue, because I think this gets right to the point of is he on his knees begging for his life? Is he standing up begging for his life? What exactly did this jury take away? Because what I took away from the first trial was he was on his knees begging for his life. What was the evidence in this second trial?
Yeah, I mean, and the evidence, it hasn't changed. The point that the defense is trying to make is that that was circumstantial evidence. That was evidence that was largely filled out by testimony, and they argue by unreliable witnesses, people who participated in the crime, right? They did make the point that there wasn't physical evidence that showed that he actually was on his knees begging for his life. Remember, they brought in that firearms expert who basically testified that you couldn't determine what body position he was in when he was killed, and exactly what the proximity was of the shooter to the victim. So that's what they're really trying to hang their hat on here, Vinny, is that the physical evidence and I guess the lack thereof.
Yeah, well, it's that image that has me riled up of a dad on his knees begging for his life to be there for his 5-year-old daughter. But wasn't there some evidence from the medical examiner about the trajectory of the wound in the head?
Yes, there was, but they also challenged that evidence, and by bringing in their own crime scene investigator and also challenging the credentials of that witness as well. So largely the testimony of Haley Bustos and some of the other co-defendants was used to really fill out the details of that image. Them talking about the fact that, or them testifying about him talking about the fact that that this poor dad was on his knees begging for his life. So that's really what the defense is hanging their hat on. This kind of gap in the physical evidence that seals it for sure.
All right, let's bring back in the think tank. Carmen Rowe, let me ask you. To me, this is what this part of the trial is all about. It's about that final moment. And does it matter if he's on his knees begging for his life, or if he's standing begging for his life, sitting in a chair begging for his life? Does it matter where he physically is standing, or is it just the fact that this young dad is begging for his life, thinking of his 5-year-old daughter, and then afterwards, they're all laughing about it?
Vinny, there's no question that this evidence is compelling. It is to me. I think it has to be to the jury because the physical evidence undermines the testimony of co-defendants. We can only believe what they say. And make no mistake, the co-defendant, Haley Bustos, in this case, is the reason this murder even happened. So they aren't just people who stood by and maybe had these conversations. They're people who participated and made this crime possible.
All right, Brian, what's the key here? Key issue for this jury in making this decision of life or death?
Well, quite simply, Vinny, in Florida, it's aggravating factors versus mitigating factors. And it's almost like keeping score on some level. What I don't like about the Florida system is heinous, atrocious, vicious. Those are so global. And God bless America, any murder generally falls within that template. What I think the Texas capital sentencing statute has over the Florida statute, and I don't know if Carmen Mayrow is going to agree, it's two global questions. Is the defendant a future danger? And are there circumstances about the defendant's upbringing, character, or background that warrant a sentence of less than death? I believe the Texas system channels jury discretion in a much more compelling manner than the Florida statute does, Vinny.
All right, I just want to bring in Joy for one more second. Joy, tomorrow jury gets the case and then they begin their deliberations?
Yeah, they're going to get their instructions. The jury will be sequestered. They're not going to have their phones. They were told to bring overnight gear in case they're not able to reach a decision tomorrow. So we'll have to see. it could be fast, as you know, or it could take some time because, as we pointed out, it's hard not to be disturbed by the crime that happened, but people are reluctant to give the death penalty. The data is showing increasingly more so.
And we've witnessed it right here on Court TV in cases down in Florida. I mean, Florida used to be much more common, but it's just not anymore. And we'll see what the jury does. Joy Lim Nakron down in Bartow, Florida, thank you so much. Think Tank staying with us. When we come back, folks, we'll take a look at the next live trial here on Court TV. All the details. Chanley Painter will join us next.